Oh yay, oh yay, oh yay. This Honorable Court of Criminal Appeals of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court.
Thank you. Thank you, Mr. Hivner, and welcome. This is the January oral argument docket in the Tennessee Court of Criminal Appeals here in the middle section of our great state of Tennessee. We have 4 cases today and 4 cases tomorrow that will be orally argued. My name is Judge Robert Wiedemeyer, and my colleagues are Judge Robert L. Holloway Jr. and Judge Timothy L. Easter. And we're pleased to be here. We, of course, would much prefer to conduct court in our normal fashion in the courtroom in the Supreme Court building. But we are very grateful to the Administrative Office of the Courts, and in particular to Clerk Jim Hivner and his staff for handling the technology to allow us to proceed in this fashion during the pandemic. So we're determined to continue to get the job done here in these cases. And this is the second what we call Zoom docket that all 3 of us have been involved with, and so we're happy to be here this morning. We will try to conduct this proceeding very similarly to what we would do if we were in the courthouse. We have read the briefs. Each side has 20 minutes for your argument. If the appellant wishes to reserve some time for rebuttal, let me know, and I will keep track of the time for you and let you know if you're getting into your rebuttal time. I think that's all the preliminary matters. Mr. Hivner, are there any preliminary matters before we start on the docket?
No, Your Honor, they're not.
All right, if you would please call the first case on the docket.
State of Tennessee versus Jennifer Murray Jewell.
All right, and this is Miss Butler, is that correct?
Yes, Your Honor.
All right, you ready to proceed?
I am.
All right, go right ahead.
Good morning, Your Honors, and may it please the court. My name is Jessica Butler, and I'm with the Appellate Division of the Public Defenders Conference on behalf of the appellant, Miss Jennifer Jewell. Judge Wiedemeyer, if I could request 2 minutes for rebuttal, please.
Certainly.
Thank you. So I'd like to begin with just a brief factual overview for the court's clarity as well as for the benefit of anyone who may be watching this morning. This case is fairly fact-intensive, but just to begin with kind of the case structure. Ms. Jewell pled guilty in April of 2015 to theft over $60,000. This was a best interest plea, and she was sentenced to 10 years of probation. She remained on probation without incident until she was arrested in May of 2017, this time charged with theft over $1,000 in Murray County. That arrest stems from allegations by her former employer that she created a $400 discrepancy over the course of 3 pay periods, resulting in a theft against the company for $1,200. Ms. Jewell finally had a revocation hearing in November of 2019 in Williamson County, where this case originated, and probation was revoked and she was ordered to serve her 10-year sentence. So I will begin first with the violation. As I'm sure the court is familiar at this point with our office and the arguments that we've put forth regarding probation revocations in the last several months. But I will say that this case is slightly different. Typically, when we bring these cases, we have conceded the violation and we are focusing solely on that second prong, which would be the court's decision with regard to the consequence. In this case, we're actually asking the court to review each of these steps, both the finding of the violation as well as the court's decision on the consequence.
Ms. Butler, was the defendant prosecuted in Murray County for the theft charges?
No, Your Honor. That case is actually still pending as of right now. I just spoke to the attorney that represents her in that case, and that case is still pending.
Thank you.
Yes, sir. So the bulk of the testimony that the court heard at the revocation hearing came from a woman, Miss Pennington. She was essentially hired as Miss Jewell's replacement after she left her employer. And Miss Pennington conducted an audit of sorts several months after Miss Jewell's departure. And she was the one who found these discrepancies between Miss Jewell's pay stubs and the QuickBooks system at the company. So the state presented not only her testimony, but also the pay stubs, as well as the QuickBooks documentation, as well as some other pieces of documentation. But Miss Jewell also offered her own documentation. There was an ongoing labor dispute between Miss Jewell and her employer. Miss Jewell departed the company on her own towards the end of 2016, and at that time filed a complaint with the Tennessee Department of Labor, alleging, among other things, that her employer had committed a litany of illegal business practices. Now, Ms. Jewell received a favorable decision from the Tennessee Department of Labor on April 5th, 2017. And the owner of the company, Ms. Reed, said that she did not recall contacting the Maury County Police Department 2 days afterward, but nonetheless, within several weeks of Ms. Jewell receiving this favorable decision, Maury County Police had been contacted and Ms. Jewell had been arrested on these new charges. And so certainly the timing of that is not only odd, but it really points to the possibility that these allegations were retaliatory in nature. And again, the fact that Ms. Jewell still has not actually been convicted of these charges lends some credence to the fact that these allegations may not have been fully substantiated. And yet, when the court made its findings of fact, the court completely ignored both the documentation that Ms. Jewell submitted, as well as some of the odd timing of this case. The court's findings of fact focused almost exclusively on Ms. Pennington's testimony, really to the exclusion of the documentation and the defense that Ms. Jewell put on herself. And it's not just as simple as Ms. Jewell testified and the court found that she wasn't credible. I think that would have been fine, but the fact that Ms. Jewell, who was, of course, entitled to a hearing and, of course, entitled to an opportunity to mount a defense, incumbent in that is that the court would consider her defense and make a finding of fact based on the documentation and the evidence that she put forth. But the court failed to do that in this instance. So it's our position that the court reached its findings based on an erroneous consideration and assessment of the proof, because that was an incomplete assessment. That if a trial court does not review and consider all of the evidence available to it, that its decision is inherently erroneous because it has not considered everything. And we would argue that that is an abuse of discretion, and of course ask this court to review that and to reinstate Ms. Jewell to probation based on those facts.
Let me ask you this. To make a credibility finding that Mrs. Pennington was credible, doesn't that imply that the court heard all the evidence that was presented before it, and then, based on all the evidence, made a credibility finding?
Well, the court didn't explicitly say that it found Ms. Pennington credible, but certainly your point, well taken, that the fact that it spent so much time on Ms. Pennington's testimony does indicate that it found her credible. And I think the issue is the exclusion of any findings one way or another with regards to the evidence that Ms. Jewell put forward. Certainly, if the court had reviewed all the evidence and said, I find Ms. Pennington to be credible and outlined why that was, but also made mention that it had also considered the evidence that Ms. Jewell put forth and just did not find that to be credible information, I think we'd be in a different position here. Because the way that the findings of fact read at this point is that the court never even considered Ms. Jewell's evidence. And so, quite frankly, we really don't know whether the court found Ms. Pennington credible to the exclusion of that evidence, or if the court simply disregarded that evidence and made its decision solely on Ms. Pennington's testimony.
Well, of course, we haven't read the records, we've just read the briefs. But the way I understand it, once the court made the credibility finding that Mrs. Pennington was testifying truthfully, or at least she was knowledgeable about what she was testifying to, then to me it seems it's irrelevant, or it's not relevant to the case, why Mrs. Reed went to the police, or what happened in some type of employment lawsuit. Basically, the court concluded that based on Mrs. Pennington's testimony, Mrs. Jewell stole $1,200 from the company. Is that correct?
Yes, Your Honor. So I think there are a few issues with Miss Pennington. First of all, Miss Pennington was hired to come on after Miss Jewell had left. She came in several months after the fact, and so really didn't have, that direct knowledge of Miss Jewell's activities prior to leaving the company.
Did Judge Woodruff know all of that at the hearing? Was he informed of how long Miss Pennington had been with the company?
He was, Your Honor. He was.
And still nonetheless made a finding by preponderance of the evidence that Miss Jewell had violated probation.
That's correct. And I think the issue is not necessarily, we're not necessarily taking issue with the fact that the court found Miss Pennington credible. It's that based on the way that the court reached its findings of fact, it does not appear that the court ever considered Miss Jewell's evidence. And therefore, we don't know if, had it considered that evidence, it would have still found Miss Pennington's testimony to be credible. If it were clear from
Is there some requirement that a probation violating judge make those kind of findings? I believe A, but not B. Is there some requirement that he or she's required to do that, the judge?
Well, I think, Your Honor, incumbent to the process of having a violation hearing is the defendant's ability to put forth proof and have that proof considered by the trial court. And if the trial court doesn't essentially show its work, we have no way of knowing if the court actually considered that testimony or that evidence. So not that it's statutorily required necessarily, but that incumbent to the process is a consideration of whatever defense the defendant might attempt to mount.
You're not suggesting that the probation violating court make written findings, are you?
Not necessarily, Your Honor. I know certainly courts differ in how they do this, but I do think findings of facts on the record, just orally spoken, are sufficient so long as those findings make it clear that the court has considered all that was available to it. And that's simply not what we have here.
Let me ask you this. Were the facts of the Murray County case, in the manner they allege she stole the $1,200, basically the same as the facts in the Williamson County Circuit Court case, at least concerning changing the tax withholding and the wage amounts?
That's correct, Your Honor. They are very similar types of offenses. And the court did hear some testimony that Ms. Reed became aware of Ms. Jewell's prior Williamson County case at some point before all of this occurred. But yes, the two are fairly similar in nature. I'd next like to move to the punishment aspect of this. Obviously, this is pretty well-traveled ground at this point. The court is fairly clear on our position. Essentially, we would argue that a trial court can pick confinement, can choose to order a defendant to serve their sentence, but that it is also possible that it can still abuse its discretion by picking that option in some instances. And certainly, Ms. Jewell, she's in her late 50s. This was her first violation. This was a nonviolent offense. So it's our position that the court erred by ordering a 10-year sentence to be served based on those factors. Certainly, the court has that option to order confinement, but that when you view the situation kind of in the totality of the circumstances, that confinement is not necessarily the best option in every instance. And Ms. Jewell's age, her nonviolent history, the fact that this was her first violation, each of those kind of weighs against ordering confinement when the court had other options available to it, whether that be a shock confinement, shock sentence, or modified probation with more stringent conditions. And certainly the court is aware of the governor's criminal task force and the recommendations that task force has brought forth. And ordering confinement for someone who will be, bordering 70 by the time they are released, if she's required to serve her full sentence, that really goes against those recommendations, and certainly doesn't address Tennessee's incarceration issues at the moment. So I will not belabor the point on that one. I will just say that we would ask the court to review not only the trial court's decision with regard to the violation, but also the consequence, and ultimately reinstate Ms. Jewell back to probation. And I will await rebuttal at this point.
All right. Thank you, Ms. Butler.
Thank you.
Let me just ask, before we move on to the state, let me ask you a quick question. Actually, it's two. The standard here that the trial court was using was, as Judge Easter pointed out, by a preponderance of the evidence. In other words, it was more likely than not that the probation was violated. Is that your understanding of it?
That is my understanding, Your Honor.
All right. And from the briefs, which, by the way, your brief and the state's brief were excellent briefs. But from the briefs, I got the impression that maybe the primary factor in the trial court's mind in imposing confinement was, I think Judge Holloway already alluded to this, was just basically there's an original crime, probation is granted, the defendant is out on probation, and then here comes another crime that's, I wouldn't say identical, but very, very similar to the first crime. So the commonsensical argument or logic from the trial judge is, if this woman is not in jail, she's going to continue to commit these types of offenses. That's the impression I got as to maybe that was the primary factor in this trial judge not choosing some other option like different restrictions or community corrections or something like that. Do you agree with that assessment of the proof in this case?
I do. That was also the impression that I got from reading the trial court's findings, that it had concerns about Ms. Jewell essentially committing this type of offense again. And that's why I think maybe shock treatment or more stringent, more modified conditions may have been an alternative in this case. That maybe the court could have limited the types of employment that Ms. Jewell could seek out, things of that nature, not necessarily to, on her first violation, say, okay, the only option I have is to impose a 10-year sentence. I think that there was a middle ground that the court could have chosen and simply didn't.
Let me ask your colleagues in your department on these types of appeals. I agree there were plenty of things the court could have done, but the statute, the way I read it, says the court has a right to reinstate the original sentence. What do you think the legislature meant by giving the court a right to reinstate the original sentence?
Well, I think the statute is very clear that when a person is found to have violated their probation, the court has at least 3 or 4 options before it. It can reinstate, it can modify, it can order confinement, one of those options. And I think that the court is within its right to pick any of those options. I guess where we seem to be having a hang up is just because the court can make that determination does not necessarily mean that the court always should make that determination. And so that's really our position, that in some of these instances, it's not necessarily the prudent decision to order confinement. That certainly the court has that option, but just because the court has the option does not mean that the court should exercise that option in every instance. And we would argue that this is one of the instances where the court should have found an alternative to incarceration.
Do you think the court is required to have a hearing to make that determination?
I think just with respect to the punishment.
The consequence.
The consequence, okay. I don't think that that's in the statute per se, but I do think that in practice, and certainly in a lot of the case law that we've seen, that is what typically occurs. But I don't necessarily know if it's statutorily required. Yes, sir?
Is it what the legislature intended, since they did not put the requirement of a hearing in the statute?
I would say that it's absent from the statute. So the assumption would be that the legislature did not intend for a court to have to hold a hearing on the violation.
How can a court abuse its discretion when it's not even required to have a hearing?
I think that while the court is not necessarily required to have a hearing, typically in these matters, the court is fairly well versed in what's happened while this defendant has been on probation. They typically receive some kind of documentation from a probation office. So they have a sense of what's going on, whether or not they actually have the defendant testify on the stand and give an explanation. So I think that in making these determinations, the trial court typically always has some type of proof before it to make that determination. And I think that it's entirely possible to make that determination and to order confinement or to reach an alternative decision, whether or not you hold a formal hearing.
All right. Thank you, Ms. Butler. And you still have your rebuttal time. General Ball, good morning.
Good morning. May it please the court, Ben Ball on behalf of the state. Here, I think both of the defendant's issues come down to the same question. Was there substantial evidence of a violation? And that resolves both of these questions. And here there was substantial evidence of a violation. We have the testimony of not just Ms. Reed, but of Miss Pennington. The trial court made detailed findings showing that it accredited these testimonies. And as far as I guess what I would describe as the sort of allegation of bias against Miss Reed, it's important to note that the dispute over the unemployment issue was ultimately resolved in favor of Miss Reed on appeal. And it's also important to note that it's Miss Pennington, not Miss Reed, who provided the bulk of the evidence of the theft. And the trial court accredited that, and that is certainly substantial evidence of a violation. When we have substantial evidence of a violation, it cannot be an abuse of discretion to revoke probation. I know we've covered this issue over in multiple cases addressing this issue. I think the state's position is clear on this, but I'm happy to answer any questions about it. But the authority case law, it's clear that when there is substantial evidence of a violation, it's not an abuse of discretion to revoke. And the trial court certainly wasn't required by statute to make detailed findings about why it chose to revoke. Judge Easter, as you pointed out, there's no requirement that they even hold a hearing on the revocation side of it, on what the punishment side of this is. And there's certainly no requirement.
Last time we heard this argument, I think you were in that same chair. You didn't seem to necessarily agree with that, and your brief seems to suggest otherwise. Your brief says the determination of proper consequences of a probation violation is a separate exercise of a trial court's discretion, and you rely on the case of State versus Reams. And
based on those positions are mutually exclusive. The idea that there's not a requirement for a separate hearing, but that it's a separate abuse of discretion, a separate exercise of discretion. But the case law is clear that exercise of discretion is not an abuse so long as there is, for revocation, so long as there is substantial evidence of a violation.
We don't apply an abuse of discretion standard to what the probation violating court does as a consequence. Is that what you're saying? What kind of standard do we apply as a reviewing court to what the trial court did or the probation violating court did as consequences? What kind of standard?
The case law is clear that it says it's an abuse of discretion, but that it's never an abuse of discretion to revoke where there's substantial evidence of a violation. Essentially, the trial court has given several options, and if it chooses amongst those options in light of a substantial evidence, it's not abuse of discretion. And here, the evidence is beyond substantial.
We did something like increase the sentence, make the sentence more onerous than it originally was. That's an abuse of discretion.
Absolutely, Your Honor. If the court does something that is not within those bounds described by the legislature, that would absolutely be an abuse of discretion. But here, the trial court revoked, and given that there was ample evidence of a violation, that wasn't abuse of discretion. If this court has no further questions, I would ask this court to affirm the judgment of the trial court. Thank you, Your Honors.
All right. Thank you, General Ball. You've got rebuttal time. Ms. Butler, if you wish to use it.
Thank you, Your Honor. One thing I do want to clear up, Mr. Ball is correct that the labor dispute was ultimately resolved in favor of Ms. Reed, but that decision did not come until June of 2017, almost a month after Ms. Jewell had been arrested. So the ultimate decision on the dispute is really not the issue. It's the fact that Ms. Jewell's appeal was successful just 2 days before Ms. Reed contacted the police. How it was ultimately decided is really not the issue that we're focused on today. So I did just want to clear that up. The second thing, as I listened to Mr. Ball talk, it seems that the state's waffling on this position really highlights what's our ultimate goal is to get the Supreme Court to hear these cases and kind of clarify the proper standard in these cases. Obviously, I know that Mr. Ball did not write this brief, but the state's position in this brief was that there are two separate exercises of discretion. And so it seems that in that instance, we are in agreement, even if certain panels of this court are not. It seems that at least we are in agreement that there are two separate exercises of discretion. And yet, Mr. Ball, what I seem to hear him arguing is that there are two separate exercises of discretion, and yet if there's substantial evidence of a violation, there can never be an abuse of discretion on that second prong. And that is not our...
With the example that we gave, you increase the sentence, that would be an abuse of discretion. If you made the sentence more onerous, I believe I heard him agree with that. So
well, actually,
if the court does one of the three things that the statute says it can do, then it's not an abuse of discretion. And you disagree with that?
I would slightly disagree with that, Your Honor. So I think if the court made the sentence more onerous, if it extended the sentence, then we wouldn't be talking about abuse of discretion. We would be talking about an illegal sentence, essentially. So that's not really an abuse of discretion. I think the abuse of discretion occurs when we're talking about what decision the court makes within those three options. Not that it goes outside of those three options. I think that would be a different situation. That would be an illegal sentence, and the defendant would still have a right to appeal on that basis. The problem that we have now is that courts are allowed to pick any of those three options, and there seems to be no way for the court to abuse its discretion when picking those options, essentially making any right to appeal toothless. If there are no other questions, I will leave it there. Thank you so much.
Don't get me wrong, Ms. Butler. I understand your argument, and you're making it very well.
Thank you.
All right. Thank you both, counselors. And that concludes this case. We'll be in recess until 11 o'clock.
The Honorable Court is now in recess until 11 a.m.